Good afternoon. This is an update on a legal ethics attorney discipline matter from the state of Iowa. Iowa Supreme Court Attorney Disciplinary Board versus Carmen R. Anderson, number 24-1894. File May 16, 2025. This is a reprimand of an attorney who missed a number of deadlines in handling appeals. The deadlines were missed. The lawyer did complete all the work on the appeals, and none of the clients was prejudiced. So the Iowa Supreme Court concluded that it would be a public reprimand rather than a suspension. The disciplinary regulator in Iowa had argued for a suspension of 30 days. I'm going to quote a little bit of the opinion here. Quote, "This matter raises the question of the appropriate sanction for an attorney who admittedly failed to comply with appellate deadlines in numerous appeals over a period of almost 4 years. We conclude that a public reprimand is the appropriate remedy here, but we caution that going forward, an attorney's repeated failure to comply with appellate deadlines may warrant suspension." And the factual summary, quote, "From December 19 through October 2023, attorney Carmen Anderson failed to act diligently in 24 appellate matters. In those 24 cases, Anderson missed 42 appellate filing deadlines, was issued 24 default notices by the clerk of the appellate court, and was removed from 4 of those cases by this court. She paid the accrued $150 penalties assessed for each default, totaling $3,600. Although Anderson's conduct delayed or potentially delayed the disposition of these appeals, none were dismissed due to her lack of diligence." And the court then holds that she violated Rule 1.3, 3.2, and 8.4D. Rule 1.3 requires lawyers to act with reasonable diligence and promptness in representing a client. 3.2, a lawyer shall make reasonable efforts to expedite litigation consistent with the interests of the client. And 8.4D, prohibiting conduct prejudicial to the administration of justice. The lawyer did not contest the findings. She admitted that she made the mistake, but she argued that the sanction should not be a 30-day suspension, but instead should be a reprimand. And she was successful in that appeal. So let's look here. The court's opinion, as in Tyndall, it's another case. Quote, "There were aggravating circumstances here. Anderson was admitted to practice in 2010. And her 15 years of experience is an aggravating factor. Anderson's prior disciplinary history is an aggravating factor. This factor is significant here because Anderson's 2019 public reprimand was based on the same or similar conduct at issue in this case. These current violations demonstrate that Anderson has not learned from her previous disciplinary history. So this is an issue that had come up with the lawyer before. The court found some mitigating factors, that the lawyer did court-appointed work and did work for low-income clients. She's active in community service, served on the board of a company that places disabled adults in family homes. The key mitigating factor in this case, however, is the lack of prejudice to Anderson's clients. Quote, "No client filed a complaint with the board. Anderson paid the penalty assessments associated with the notices of default. Generally, we are reluctant to suspend attorneys solely for default notices cured without dismissal of the appeal. After taking account of the aggravating and mitigating circumstances, we conclude that a public reprimand is the appropriate sanction here." So the lawyer did very well, considering it was their second trip to the Iowa Supreme Court. for missing appellate deadlines. And then the final paragraph contains a warning. Quote, while we conclude that a second public reprimand is the appropriate sanction consistent with our precedents, we note that missing deadlines is not consistent with the duties required of Iowa lawyers, and that going forward suspension may be appropriate in future cases involving this type of wholesale neglect of filing deadlines. And then they quote another case, using the appellate clerk's notices of default as a private tickler system is unacceptable behavior for an attorney. Attorney reprimanded. This attorney did extremely well in this discipline case considering the number of violations. The attorney should be very glad to have just escaped with a reprimand. Appeal deadlines, all these sorts of things are important, shouldn't be missed, and can subject you to significant risk of sanctions and or discipline. If you're struggling with your workload so that you can't get these appeals done, you need to reduce your workload. Find someone else who can help with these appeals. Contact the Bar Association. These may have all been pro bono criminal appeals. I don't know what they were. You just have to find a way to get the work done in order not to take this much work. So this is a note for anyone who's involved in the practice of law. That you got to get your work done, and you're going to face discipline if you don't. This lawyer was exceedingly lucky and fortunate, and it appears to be a very hard-working person who rendered a lot of good service to clients, and should be very glad to have received a reprimand, not a suspension. Thank you. That's our update for today. See you soon.